But there could now be a custody battle brewing over one of those girls, Alexandria. Her biological father signed over his parental rights to her mother, and she is now, of course, the daughter is legally in the custody of her stepfather, Gary Bain.
But Mark Johnson is afraid Bain will apparently move out of state with his daughter, and he doesn't want that to happen.
Miles Mason handles tough custody questions just like this as a family law attorney. Now, it is important to note he is not involved in this particular case, but is here as a general expert. Miles, always good to have you on board to explain all this. How, first of all, in ordinary situations, and this is obviously an extraordinary case, how difficult is it to give up parental rights completely in the first place and then to get them back if you do change your mind?
Giving up parental rights requires another person to take over those parental rights in general. Okay. So whether somebody's in prison and going to be in prison long term, or just isn't able to support a child like they would otherwise want to, once you give up those parental rights, it's a termination of parental rights. The biological father, in this case, according to black letter law, has no rights to visit, see, talk to, spend time with, inherit
just as if
from.
He was never the father.
Never
you
the
just
father.
wipe it clean, almost.
Completely clean.
Wow. Miles, what about, I realize each case will be different and is different, but what about the emotions that usually play into cases like this, though? What do you typically see?
It's a huge factor. I mean, the law says one thing, but a judge who may be presiding over it may feel differently about it, because is it fair? Having a biological parent unable to speak with or interact with a child interferes with our fundamental beliefs of what is right and what is just. But that's what a termination does. So you have a conflict in the mind of a judge. Do I do what I think is right, or I do what the law requires?
So obviously, on the part of any parent considering this, know that it is pretty much irrevocable. I'm trying to say the word. You can't take it back.
Cannot take it back.
What is
it's
that
final.
word?
Final, final, final.
But in this case, with these extraordinary circumstances, I mean, his daughter was kidnapped, held several days. Her mother was now murdered. I mean, would that play into whether or not he has more leeway?
What he needs to do is negotiate a resolution. The new parent, the adoptive parent, can say yes or no, and that's going to be in his sole discretion. Now, if he says and thinks that it's in the best interest of the child to allow some type of interaction, the stepfather, now the parent, can allow that.
Miles, is this a state-by-state law? Is this a federal law? What are we looking at here?
Well, of course, we have 50 different states. We have 15 different sets of family laws. But this is pretty standard across the United States.
And when it comes to, as you said, negotiating, how typical is that these days?
Well, like you said, this is a very, very unusual case. But usually, if it's going to go to court, it's heated. It's been tried to negotiate that. It's failed. And so there's a complete breakdown. Court is going to be a last resort for either parent. So the biological parent or now the adoptive parent.
So in these cases, you would advise a client to do whatever they can do to avoid court, because obviously that just further damages the child, does it not?
Well, normally what we try to do in the court system is keep the children out of it so that they don't know anything about what's going on. In this case, if there's media coverage, well, that's going to be tough.
Yeah.
It's going to be tough.
Yeah. Man, does a child have any say in this if it does go to court?
An older child may, okay? And it depends upon the maturity level and age. And for example, in regular custody cases, a child that's 12 or older may express a preference, but judges are not going to pay attention to that preference in terms of that making the decision. One exception, say you have a 17-year-old that is driving, living their own life.
Close to independent.
The judge is going to listen to a 17-year-old a lot more than a judge is going to listen to a 13-year-old.
In this case, you've got a 12-year-old who's certainly been through trauma. That, I'm sure, would weigh into a judge's decision to listen.
I would hope that no one would ask the child for her opinion.
Okay.
Yeah.
That's what I would hope.
All right.
Because a child put in that position feels like they're in a position of choosing and hurting somebody.
Yeah, she's already been through enough.
Miles Mason, thank you very much for being with us this morning.
Miles' number on the screen if you have questions about your family situation. Thank you.
All right. We appreciate it. All right.